Yes, call the list, please.
Item number 1, pronouncement of judgment.
Even if our answer to these two questions is against the appellant, does this mean that the right of a selecting authority to appoint candidates from the waiting list of a selection process which had been concluded was being exercised by the selecting authority? When the High Court acceded to this request, could it be said that a policy decision in this behalf had been taken? Even if our answer to these two questions is against the appellant, we hold on the basis of the above authorities that subsequent appointments of the respondent numbers 4, 5 and 6 on 28th February and again on 4th March 2022, on the basis of which all three joined duties on 3rd March and 4th March 2022 respectively were invalid. It is plain that these respondents have been discharging their functions for well over 3.5 years. Two judgments cited by Learned Deputy Solicitor General, 2024 3 SCC 799, paragraph 55, and 2024 2 SCC 269, come to the rescue of the government. The Supreme Court took into account the long service which the judicial officers had rendered, the experience they had gained, and the contributions they had made to the judiciary, and declined to unseat them. Here the service rendered by the respondent numbers 4, 5 and 6 is similar in nature. Hence, we are of the view that their service should not be interfered with. Mr. D.K. Mishra, learned senior advocate appearing for these respondents, also made similar arguments. He did not fail to argue that the induction of his clients from the waiting list was further to a considered policy decision of the selecting authority with the concurrence of the High Court, based on grave urgency to fill up the vacancies for the cause of speedy judicial administration during the COVID period. A silver lining in the sky occurred during the close of hearing of this appeal, when Learned Deputy Solicitor General remarked that there was existing one vacancy and one future vacancy to arise soon. Taking into account those submissions, we direct that to have a fair and just result, the clock should be put back where it was when the 3 posts were filled up from the waiting list. This could be done by creation of 1 supernumerary post. There should be no difficulty in this, because the Council has repeatedly urged that it was in need of more judicial officers to dispose of pending cases. Hence, we direct the Council and the State to create 1 supernumerary post. Any approval from the High Court or the government is deemed to have been obtained. Such supernumerary post should be created by 30th September 2025. Thereafter, selection test to fill up these posts should be carried out, where the appellant is at liberty to participate and to be concluded within a further period of 3 months. In this way, the grievance of the appellant is also redressed. In view of the above, this appeal is disposed of.
I'm deeply.
There's a lot of mistakes. Minor mistakes, some pages may be changed. Minor mistakes. Like this. They will change the page. You check up.
Number 2.
You can have a look at the pages. Yes. No, you can type on the basis of. From here, I will also check out this. If there are any other. Yes, item number 2.
May it please, Lordship.
Yes.
Lordship, this appeal is preferred against an order which is passed by the Commercial Court, London Commercial Court at Geelong, whereby, my lord, the suit which the commercial suit which was filed was disposed right under Order 7 Rule 11 for non-compliance of Section 12A of the Commercial Courts Act, my lord. So, aggrieved by that impugn order, Your Lordship, we are before this honourable bench, my lord.
Your Lordship, I'm appearing on behalf of all the respondents, Your Lordship. Your Lordship, we are praying for 4 weeks' time since we have just received the copies, Your Lordship.
Copy of what?
Copies of the appeal.
4 weeks.
You had pleaded that urgent reliefs were contemplated.
Yes, my lord. We have, in fact, we have filed a missed case, my lord.
Yes.
But despite
What was your suit about?
my lord, it's a commercial dispute, my lord, for infringement of copyright and trademarks, my lord.
So what you must have been praying for an order of injunction.
Yes, Your Lordship. In fact, my lord, if I may take Your Lordship to page 72, whereby the Commercial Court has granted the ad interim injunction, my lord, in our favour. But subsequently, my lord, that ad interim injunction was vacated by a subsequent order which was passed by the Commercial Court for non-compliance of.
At the time of institution, you have to take exemption from compliance with 12A.
Uh,
You filed it just like that.
no, Your Lordship, along with the suit, my Lord, we have filed an application.
Yes. But without that application being considered, the suit was received.
Yes, Lord.
And you moved the application.
Yes, we moved the application. In fact, the application is still pending, my Lord, which matter is still to be heard on merits, my Lord.
Injunction.
Yes.
But
Order
you said
59.
injunction was already granted.
The injunction was granted, and subsequently, my Lord.
The application is pending.
Yes, yes, Your Lordship.
But how the suit has been dismissed, so application gone.
True, Your Lordship. But if Your Lordship, if I may take Your Lordship to
You show the plaint.
Your Lordship,
This is an absolute misuse of this act which is going on.
if I may take Your Lordship to page 72, which is the ad interim ex parte order, my Lord.
No, you show the plaint.
The plain will be at the application will be at page 59, my Lord. The prayer is at page 68, Lordship.
It is all right, but your main thing is the plaint, which should contemplate urgent reliefs.
Yes,
Application is all right. Where is the order?
Order is at Annexure 1, page 25, Lordship. The impugn order.
Copyright matter. Urgent interim order is always necessary. 12 says that if no urgent reliefs are contemplated in the claim, you have to undergo mediation. If urgent relief, then you can file it without mediation. The prayer is hopeless order, we are setting it aside. What is all this? Please take down.
may it please Your Lordship. Your Lordship, since the conducting counsel further
No
expired yesterday,
conducting counsel business.
so
He has filed a suit, copyright, where an order of injunction is routine. He will not wait till disposal of the suit to get an injunction. Immediate injunction he will ask for. And the suit is aborted. Order 7, Rule 11, reject. Not even return of the plaint. That undergo mediation and come, reject, which is a decree.
In fact, my Lord, we are with limited prayers before this honorable court, my Lord. If matter, the limited prayers that, my Lord, since if matter could be revived and sent back on remand, my Lord.
Yes, and you move the injunction application, that will be considered by the learned judge on merits. The plaint cannot be thrown out. Please take down.
Your Lordship, sorry to interrupt for the last time.
I'm sorry.
I'm
We
just
are very sorry, no. if we give you adjournment, that time will be utilized by you to infringe the copyright.
I understand, Your Lordship, but the main conducting counsel father
We have
expired
heard you.
yesterday, so I don't.
You
see-
go and fight out the main injunction application before the learned district judge. We admit this appeal. As the facts involved are very serious and urgent in nature, dispensing with all formalities, we have proposed to hear out the appeal today. Paragraph. We are absolutely surprised to read the impugned order dated 17 June 2025. Where are the press? Suit for declaration is. The plaintiffs instituted a trademark action being commercial suit number 3 of 2025 against the defendants in the court of the judge commercial court at Shillong. In or about April 2025. Full stop. It alleged infringement by the defendants of their registered trademark quotation YY WAI WAI by the defendants by registration of a mark quotation Walkway WOK WAY separate. And or passing of and or the defendants passing off their goods as those of the plaintiffs. On the face of it, this kind of a suit calls for urgent reliefs in the form of an injunction restraining the defendants from using the mark. It may or may not be pleaded specifically in the plaint that within quotation, urgent relief is contemplated. The grounds for such urgent relief are usually made out in the interim application in aid of the suit. Paragraph. The learned judge committed a serious error in where is the main order? Which page?
Your Lordship, it's at page 25, my Lord. Annexure 1. It's the impugn order dated 17 June 2025.
The learned judge committed a serious error in rejecting the plaint. We set aside the impugned judgment and order dated 17 June 2025. So we allow the appeal. You made an application on the 12A in that court.
Yes, Lordship.
Which application is that?
Your Lordship, it's application bearing commercial miss case number 14 of 2025, whereby the commercial court has also granted an ad interim injunction. If your Lordship could kindly have page 73, my Lord. The application is at page 59, and this order dated 1st May is at page 73, my Lord.
No, this is the interlocutory application.
Yes, ma'am.
Where is the 12A application?
You also would find that at page 55, ma'am.
The impugned order page, you said 20?
The impugned order is at page 25, Lordship.
This order is to be taken as one under section 12A of the Commercial Courts Act, permitting the appellants to plaintiffs to institute the suit without undergoing the process of mediation. The suit is revived. Any interim application pending before the court on the merits of the case may be considered by the learned district judge in accordance with law.
I will write a lot.
Number 3.
What did the Supreme Court say?
So, sorry, Your Lordship, I have not received the notice. I am not aware of.
Here it seems that the Supreme Court
Lordship.
in 2018 had directed demolition of illegal religious structures on government land, or dealing with the same so that they exist according to law, like regularization.
Regularization, Lordship, yes.
So it was taken cognizance of by the court, but in its administrative capacity. The then Chief Justice sent a note out that you comply with the order. So the order of the Supreme Court has been complied with.
Not seen.
The government has sent a report to that effect. But since it has been sent by the Supreme Court, I directed that a PIL be registered and this compliance be recorded accordingly, since Supreme Court's order is involved.
Not yet.
Yes, we have to record it. That is why I said.
Also, if a copy is given to us, at least
Yes, yes. Further to the administrative order of the Chief Justice, dated 14th August 2025, the Registrar General has started this public interest litigation paragraph. The purpose of initiating this litigation was to ascertain compliance with the order of the Supreme Court in special leave petition, this. And the order dated 31st January 2018 passed therein. At the request of Mr. Khan, Learned Additional Advocate General, let the Registrar General forward all the relevant papers of this case
Not yet.
to him to enable him to take suitable instructions in the matter. Paragraph, we may note here that in an affidavit filed on 25th April 2016 by the state and the additional affidavit dated 3rd September 2013, what have you written? What have you said? It has been asserted by the state that 3 religious structures which have been constructed on government lands at West Garo Khasi Hills and 4 religious structures at East Garo Khasi Hills district, or East Garo Hills district, were being quotation regularized. So furthermore, there is no illegal encroachment of public roads, sidewalks, etc. by religious structures. The learned additional Advocate General is expected to file the latest report to enable this court to dispose of this petition. We make this application returnable on 1st September. Let all papers be handed over to Additional Advocate General by the Registrar General by when is he coming back? When is he coming back? All right, you make it 2nd September. Papers be handed over by 27th August.
Lost. We can forward the orders to the department.
Number 1, pronouncement of judgment.
I find the improved judgment and order dated 20th February 2024 to be a proper exercise of discretion and otherwise sound. There is no scope of any interference, save and except that, considering the long period of interest payment and involvement of government revenue, the rate of interest at Roman 4 under the heading calculation at page 45 to 46 of the said judgment shall be at the uniform rate of 6% simple interest per annum.
Yes.
The improved judgment and order so is affirmed as modified.
Deeply.